Hello, everyone. Welcome back. Welcome from Munich. We have an excellent weather outside, and I hope we can match that with the content of this webinar session again. It's a very special webinar. We are going into new territory, looking into the legal and regulatory aspects of trading. And I'm very happy to have Jens Hartmann with us. He's not just the managing director of Correggio, but as well board member of the EFET organization. And in this role, I think there could be no one better guiding us through current trends and developments in the legal and regulatory environment. We'll touch Brexit, COVID, etc. We make sure that this is not becoming a very, let's say, theoretical discussion here. We are all very pragmatic and practitioners here. So we count really on your contribution by questions. Put them again, please, in the chat or in the Q&A function you see down there. No long talk from my side. I'm happy to have you, Jan. I directly hand over to you and hope to have a lively discussion after your short presentation.
Thank you, Jens. It's not a boring year, 2020. We all remember it probably for the rest of our lives. Yep. Because all of us have changed the way we are living through to all the circumstances. And it's a pleasure for me to be here. Obviously, happy to be your guide. Ultimately, in our lives, we have to guide ourselves. But if it's good, then if you have good advisors, I think that helps in life, as we have seen in the past. Now, I have prepared a couple of slides for you, but ultimately, please feel free to actually ask questions so that we're getting a little bit more of a discussion going. Otherwise, it is getting boring. I will share these slides now. Hopefully it works. So, should work. Does it work?
We see it, yes.
All right.
Oh, sure. Yeah.
Now we're getting there. Just hold on a sec. That's it. Yeah, current challenges in trading. There are multiple. There are multiple challenges we've had this year, certainly due to circumstances which have also meant a huge volatility in prices, because this is what we are really living off in the traded markets, is what we're getting for the commodities in it. So I'm thinking of three topics that are not necessarily interrelated, but happen to happen at the same time. So there is the Corona crisis and general things, how it impacts or may impact you. There is Brexit, a topic which most of you have already been living with for a number of years, I should say, because there have been several Brexit exit dates that were then rescheduled. So I think today most of those Brexit issues, as far as foreseeable, and this is an important limitation, of course, as far as foreseeable, I think we are now aware of what these impacts will be. The last point really are compliance risks, fragmentation of the industry regulation, ways of mitigating this. Looking, the first one, COVID, what has it really meant? So far, trading goes on as usual. We cannot see that we have had any serious breakdown of infrastructure. Everything works fine. So it shows also how we actually can organize perfect market functioning more or less from home, because most of you are sitting at home as you are listening here. However, what has been happening as well is sort of a decreasing creditworthiness of a number of companies due to the circumstances of economic crisis. There obviously is a higher credit exposure, which will also impact trading at a certain extent. Also, we haven't seen any trader going bust. It is more about the clients we're worried about. And so far, we are seeing a situation whereby companies cannot really go bust, so to say. You can see here, for example, moratoria that are currently running in Austria until end of January next year. In the Czech Republic, the Lex COVID, even until June 2021. In Germany, the duty of the Board of Directors to file for opening for insolvency proceedings for over-indebtedness has been suspended till end of this year. In Spain, a general stay of all insolvencies has been imposed until end of December. And a specific credit fund has been set up as there has been an increased risk of PPAs that are very popular in the Spanish market going into financial difficulties. So what does it actually mean, all of this? It means that we are having, in reality, an artificial protection from insolvencies, but it means also that we will have to face these insolvencies once the moratoria run out. So this is actually the point in time you need to prepare for. So once these moratoria run out in the respective countries, we are expecting a wave of insolvencies. Once again, less maybe on the trading side, but maybe on your customer side. So this is something for you to look at. Keep an eye on the insolvency laws and their change in COVID times. And this is something to manage your credit portfolio, you manage the credit exposure. Having a increased attention to this is probably good advice looking forward. Now, coming to Brexit has nothing to do with credit or with COVID. It just happens to be in the same year. So we don't seem to be happy just with COVID. We need Brexit on top. And the good thing about Brexit is that we have more or less prepared for it. We know that there are issues relating to market access for entities that are based in the United Kingdom. Many trading companies are based in London. They are operating out of London, and what we have seen in looking at the various market access is that for the countries you see marked up in red here, there will be a market disclosure in case of a hard Brexit, meaning a no-deal Brexit. Most of the market participants know that, but if they don't, they know it now. For if you haven't done anything, this is where you basically will be precluded to trade, physically trade, either by a a problem relating to your balancing responsible party status, such as in Austria, or simply by a closure of your license altogether. And that would be the case, for example, in the French gas market and also the Polish gas market. So you see there are a number of red zones, notably in Eastern Europe and Central Europe, but also in France, as far as gas is concerned. In Spain, we are not quite sure what the situation is because the Spanish regulation does provide for reciprocity for non-EU countries. The United Kingdom, in a hard Brexit, is really getting out of the system. It would then be not comparable to countries such as Norway, but more comparable to countries such as Russia, as the United Kingdom doesn't have a customs union, which equally even Turkey has with the EU. So that will also lead to customs issues, not necessarily that there will be customs to be paid, but there will be customs declarations that need to be done whilst exporting gas or power to the EU or importing from the UK into Europe. So the interconnectors are currently preparing for customs status and customs handling. Also, there is no customs to be set at this point, or is set at zero. Hopefully, this will remain the same. Now, what another area of concern is, which came out this year, is remit increased leverage for fines. You have here one for £2 million against SSE in a case where the availability of power plants were not published in the correct way in the view of Ofgem, the UK industry regulator, and which led to a fairly high fine, £2 million against SSE Generation Limited. But this one, which dates from August, is really only the last one. We have had a number of fairly interesting cases that come out of market abuse in the Spanish market, in the French gas market. We had one relating to algorithms in Germany, which was only a very small fine for a German company, but in reality, these are the test cases. We expect, looking forward, certainly for next year, more fines, higher fines, a more environment where we have to look at compliance in general, compliance meaning compliance with inside information, which is in remit, but also compliance with reporting duties. And these are in general reporting duties that could lead to fines. So far, this has not been the case under remit. We have had a fairly interesting case in Hungary, also relatively recently, for only 3,000 euros. But again, here, these are test cases for allocation of cross-border transmission rights and the publishing of availability capacity at cross-border. You know that the Hungarian marketplace is, due to the emergence of Ukraine as a traded marketplace, becoming all of a sudden much more important, and the net capacities there are scarce. So here we're having a fine for non-disclosure, which was issued against TSO Mavir. This brings us to a sort of a associate or adjacent topic, are the national reporting duties. So we have obviously within the European market space, the REMIT and the EMIR reporting, which are reportings for different instruments on a European scale. These are fairly automated. Many of you are, or if all of you are, as far as you are market participants, complying with these reporting agreements and reporting arrangements under EMIR and REMIT. And then there is what we call the blind corner, meaning really the national reporting stuff. On Correggio.net, there is now an innovative platform that has actually brought them up to one platform, meaning for 20 countries. All of these are now centrally identified. We have identified within Europe a total of 400 of those. So 400 reporting duties that either may be in the context of statistics, or in the context of security of supply, or in the context of volumes in order to calculate regulatory fees that are then due by the market participants, depending on the country they are active in. So in reality, what we have with these national reporting obligations is a blind spot, which companies have to comply with. And it's difficult to comply with them because they're all changing all the time. So it's like a moving target, and the more and more companies are going to more and more countries. So ultimately, difficult to do it. How we have done it at Correggio.net is to link the legal basis of every reporting duty to the law, translate that law into English. That was a major translation from 20 languages into English. Then also further allow to click down when the forms are provided, equally providing convenience translations of reporting forms as far as provided. So insofar, these post-market entry guides are some form of regulatory monitoring, which clearly is emerging also as far as the user base there is. In the system, you have what we call something called calendar tool. You have here reporting obligations for a certain date. So we're having here, for example, looking at July 2020, and then you see for July 2020, we have reporting obligations in Austria, in Croatia, in Poland, etc. So you see, you can more or less with this calendar function see where in your area of activity the reporting is due. This is what currently the scope is. The scope will be further enlarged by Ukraine, Serbia, and Slovenia, all by this month. So the aim is to be covering more or less the entire European continent. And that was it. It is in reality a mix of different pots, so to say, which we have put together here in the presentation. But ultimately, it gives you a little bit of a view of challenges which we all face that relate to compliance with various forms of regulation. So back to you, Jens.
Thank you, Jan, for the very good overview, I think, on the topics. Sometimes they are not directly related, yes, but they happen at the same time. So we have to deal with it. Starting maybe from the back, jumping on the questions we are getting here. The regulation in some of these countries is not just a, let's say, pain in the risk for the organization. It's as well a very effective way of preventing competition in some cases. You have an opinion on how the EU or whoever feels responsible will tolerate the prevention of competition in some of the especially Eastern European countries like Romania, Bulgaria, Poland, etc.?
This is a political question. In reality, the European Commission, in reality, has a very effective watchdog when it comes to the enforcement of the competition rules in Europe. But they also, at the same time, employ discretion, which topics are of interest for them. Mm-hmm. So it has been difficult to get their attention to the abuse of dominant power in Southeastern Europe. Personally, I was very surprised that Gazprom, that has ignored European competition rules for about 25 years, got away without a fine, whereas some American internet companies are fined with billions of euros at the same time. So to me, all of this competition approach by the European Commission is very much depending on their interests and on them taking a view on what is important for the European market or European economy, I should say, as a whole.
Yeah, I see that. But you agree as well that some of the regulations are more put in place to prevent new counterparties entering the market, or what is your experience as well of counterparties using your services now?
Well, you can always presume with some of the highly volatile markets, I just mentioned Poland or Romania or Bulgaria, I'll be quiet about others, that some of these new regulations which they put in place, they just have political motivations, that is clear. But this is something the European Union cannot fix as such. We are not one country. These are sovereign governments that decide to protect their own markets in the way they see fit. Yeah. So the European Commission can only really look at issues that have cross-border impact, so that have a wider impact into the market. And even there, they are then selective in the way that they are actually addressing those.
We received two questions. I'd like not to combine, but go through around the Brexit. So you said many things are prepared already. I still want to read one very precise question here to you. Is there any clarity regarding what will happen after the 1st of January with remit type reporting for deals where the commodity is sold or purchased in the UK? Is there already any equivalent procedure for reporting this type of information to a UK authority?
The answer is no. The answer is no. There will be like a period of time until the UK gets their own remit registry in place, and it is a period which will not start on the 1st of January. We don't know exactly when the Ofgem will put its own remit platform up and running. I expect it for the first part of the year, but there will be a period of no reporting. Meaning that probably the reporting will have to be done then backwards looking. So once this is then up and running, probably the reporting will have to be done at that moment in time. We're expecting also from Acer, that has recently been announced, some paper relating to Brexit to be expected within the next 2 weeks. So there should be further answers relating to remit and remit application in that paper, which Acer is about to publish. Right. But short answer to the question here is no, we don't know.
Two more questions here around Brexit. As a trader, can I still trade power through my London broker or London-based broker? We talked about the entities, but I guess here it's about the broker still sitting in London.
Brokers still sit in London. Why should they not sit in London? Most of the broker community have depending on what brokers they are, not every broker is the same as another broker. In reality, you have to see what sort of brokerage platform do you operate. So if you operate a platform that offers financial trades and physical trades at the same time, and you want to make sure that your customers take advantage of the carve-out, you are well advised to move this platform into Europe, meaning the European Union. And I believe most of the large brokers, if not all, have done so. They have all set up their broker activities through France, the Netherlands, Ireland. So these countries, I believe, are the ones that have been preferred insofar, yeah, but you can still continue using brokerage in UK as well for the UK delivered deals. So there is no deal. There is obviously no way of cutting this off. I think as far as let's say the trading community is concerned, their main concern is to make sure that they continue to take advantage of the remit carve-out. So that is also what currently is happening. What has not happened so far is, let's say, the transfer of staff. Most of these brokers will obviously continue to be operating out of London. They have just basically used national entities to acquire OTF licenses in the various EU 27 countries, but they have not themselves moved. Whether that will change remains an open question. I guess there may be further requests that also staff will have to move away from London, sort of make more out of these entities that are now operating in the broker market than empty legal shells. But that remains to be confirmed.
Yeah, this is where we hear that some companies are preparing to move their staff to Paris or Ireland, others not yet. So there seems to be still some open interpretation, let's say. Yeah. Good. Let us jump on here. On the insolvency risks, you have a very good overview of all the countries. One of our attendees is asking, looking at the very different approaches by European governments, in which market do you see the highest counterparty default risk? Or is there a heat map or risk map in a way?
Well, I think a large part of Europe would be in that heat map. So I don't think you obviously hit markets more where there are anyway problems. So where you are is the same with any other business. I think some businesses are now failing because of their had difficulties before. Obviously, in markets that have market participants that are economically not very stable, you will have an increased risk of failures there. And I would believe that if you look at the European map, I assume that there will be failures in the south of Europe and in the east of Europe, mostly. But there may also be failures in Germany. I mean, this whole economic circumstance only hits you in the situation you're in. If you are unstable before, you may even get more unstable, and then you may just lose it out completely, and that is independent from your residence.
Yeah. Thanks. Let me sort there. So there's one question. What happens with the UK EUAs? What will be the price effect?
Well, we don't know. This is something which is very unfortunate that the UK government has not taken the opportunity to link up to the EU 27 markets. It creates fragmentation, loss of liquidity, really very sad. So, but I mean, to make now a prognosis on or forecasting any price levels is impossible at this stage.
But we have this loss of liquidity, so it will be interesting to watch what is going on.
It will be an interesting one to watch. Yeah,
absolutely. Then one question which goes maybe beyond what we have discussed, but were quickly touched upon only, the PPA market. I will read here as well the very well phrased question. How do you feel about this wave of PPAs these days, especially with regard to evaluation matters? Companies might fill their books with long-term PPAs, evaluated with fantasy figures due to illiquid prices in the future. Then there is even a connection to Enron. So
I was just thinking, it sounds almost like the Enron story, but Moritz is obviously too young to have been in Enron. I was there. So immediately the same reflection as you have, Jens. Obviously, these PPA credit exposures are specific in the sense that these contracts are long-term and there are no price signals in the market. And this is also why your recent project, which you're setting on in enmacc, is a very good one, because it looks at creating price echoes for markets that are far away from today. Insofar, this project of yours at enmacc is fantastic, forward-looking, and should be supported. Now, how do the PPAs impact, and the credit people are looking currently at finding ways how to calculate the exposures. There is no best practice at this point in time. So every company, as is doing it in a different way. And ultimately, yes, I think this is a platform for associations such as EFET or others. There are also credit associations that could look at this, and they're already looking at it. How could these long-term credit exposures be substantially hedged? Hedges are obviously available a couple of years out, but not for the 10 years. I also know that the EEX is looking at ways how to help with risk hedging for these long-term exposures, but this is something to be done now. I mean, we have, I think so far, probably a nice pot of various recipes, but eventually we need like a best practice, and I'm pretty confident looking at a discussion round we had actually only this morning within the EFET credit group, that this is very much on the priority list of the credit managers of trading companies, looking at how to best do it with these type of agreements that are becoming more and more popular. We should also say that obviously they are not becoming popular everywhere. They are very popular in Spain and in Italy and in Scandinavia, but in Germany, where are the PPAs? And as long as we continue in Germany with the feed-in tariff forever, equally for the old historic generation, we will not see much of the PPAs.
Yes. I can say this is why we started this enmacc Echo service, just to provide more transparency and clarity on the years 25 onwards. And
yes.
I can say we started with 10 major players, all active in the PPA space. And we already see kind of a more stability and consistency in the prices since after 6 weeks of the service. So ultimately, I believe it's about bringing the PPA business closer to wholesale trading to have a real risk evaluation and not keeping it somewhere separate in the books. So that's at least our mission in this space. I guess very much as well aligned with players like EEX who have the same interest.
Yeah, and I think the market needs this. The market needs price indications for longer periods. We just need to create them. We didn't need them in the past, but with PPAs coming up, as Moritz rightfully says, we need them. We need this, and so far this new product or service which you're offering is useful.
Thank you. Yeah, great. Let us jump into a different topic. And I read that as well. There were plenty of articles now about 2 traders in New York getting kicked out because they used WhatsApp to So I'm happy about this question. I totally forgot the topic when we were preparing this call. But I mean, this was an amazing story which made the news now, that senior traders got kicked out because of that. I ask myself, really, why does someone personally take the risk of losing a high-paid job because of that? But or how do you see that as from a legal perspective? I mean, there are many levels of legal discussion you can have here.
I think this is a discussion for compliance managers.
Okay.
So I don't want to intervene in their compliance policies which they put in place. I find it's obviously also another thing that is connected with COVID. Let's face it. I mean, many people work at home. Let's say the systems are not operating the same way when you are not in the office. And this is why things like WhatsApp come up. So people kicked out of trading for WhatsApp, that sounds a little bit like big title on a tabloid.
Headline, yeah.
So maybe it's not the only reason why these traders were kicked out, is the only remark which you get from me in this context.
All right, good. Let me move on. There's again, connecting a little bit the EUA topic with trading in after Brexit. Might there be any implications on trading EUAs on the ice? So I assume the continental trader continuing to trade EUAs on ice in London.
Yeah, it is obviously nonsense that the European Union has not moved on with the equivalence decision for UK-based exchanges. I mean, ICE is based in London, and the British government has recognized the equivalence of the EU exchanges. So in reality, this is why the market participants, including EFET, have asked the European Commission to finally get out with their equivalence decision for ICE. If they do it, the problem is resolved. Now, if they don't do it, yes, there is an impact because of the different qualification of these rights being traded outside the European Union. Yeah. So it has then an impact for the, let's say, the MiFID EMIR context. EUAs are financial instruments, and they need to be properly acknowledged in the thresholds which the companies need to abide by. So yes, we really hope that the European Union, or European Commission, I should say, comes out very soon with equivalence for UK-based exchanges.
Yeah, that is for exchanges and as well clearing matters. Is that right? Yeah. So clearing service and exchanges are mostly in focus here. Is that right, from an energy trader perspective?
Well, clearing has anyway already moved. Clearing banks have moved mostly. The SocGen, others, they have already moved their clearing operations into Europe. It's mainly the exchanges. So the question here relates to ICE being an exchange outside the European Union.
All right, but you're optimistic that there will be this acceptance of equivalence?
We hope that. It's obviously, again, politics, Jens. We're all talking the world of politics. They don't want to give it without receiving something in return. It's the typical horse trading which is going on in Brussels since it has been invented. So since there is no real progress, it appears, or very slow progress as far as the future relationship of the European Union with the United Kingdom is concerned, then this is probably one of the balls in the basket. And it is really insofar bad as there will be the European companies that will be affected by it because they are trading mostly these rights on ice. So we would have clearly an interest that this either left the basket, or is resolved otherwise by the EU and the UK coming to an agreement on a wider scale.
Yeah. All right. I think we touched most of the questions we got here. Let me pick one more here. How do you feel about this new discussion whether balancing energy activations by TSO should be considered to be inside informations, and which measures do you suggest companies should put in place?
This is a discussion which requires further, I think, opinion making within the community. I think probably it's too early to take a position here.
All right, good. We discussed as well the fines which are happening in many countries or areas. Do you see this as well as a reputational damage which happens now to many of these companies? I mean, if you have big profits, you can cover as well some fines. They are not yet on the level where most of them hurt really, but is more the reputation at stake here, or how do you see?
Oh yeah, I mean, limit fines. Yeah, it is a reputational loss. Certainly, if it's a large company. Looking at Germany, for example, it was one of the largest companies in Europe being affected by a remit infraction there. It's always reputation issues, but it goes beyond this. It's also, let's say, a sign of a bad compliance culture, and that is then a signal again to the regulators they need to do more. So we don't want too many of those, because the more we are getting, the worse it's getting. So in reality, if we give the regulatory landscape, which we have created ourselves in all these different countries, the feeling that it is all working, everyone is behaving according to the rules, I think we have a much better view into the future. As far as these local requirements, which I mentioned earlier in my presentations, are concerned, they are less about the money. They are more about market access loss. So I think what these regulatory authorities do, if companies don't abide by their compliance duties, they just basically fine them. These fines will be small, but ultimately they stop the market access, and this is where the real risk lies.
Right. You mentioned the ESMA several times. How much visibility does the energy trading space have with ESMA? I mean, it's a small asset class compared to let's say bond trading, fixed income, whatever.
It is limited. Don't forget, ESMA is dealing with a different planet of different size. We as commodity traders are like mosquitoes in this planet. So in reality, the visibility is limited. Nevertheless, we get the feeling that ESMA wants more, not less. They don't seem to be as satisfied that so many of the major commodity traders have not declared themselves FSC pluses, so meaning organizations of direct control, but most of them could use their substantial exposures in physical markets to get out of that status. And maybe this is why they want to have more. So looking at the more recent discussions between ESMA and the energy regulators, I get the feeling that we have to observe that space with much attention.
So that the exemptions granted to energy, physical energy trading are up for discussion in a way.
Yes, we are fighting. We need to fight for those. And we have a very good team in EFET that does that, led by a very efficient management. So in reality, I have to say, we have to be aware that this is an area where we need to continue making our point. And if we don't do it, we lose it. So I think here, work has been done well. We have been successful in at least getting the remit carve out, defending it, but also successful in the keeping the ancillary activities exemption from MiFID, which helps a lot for the asset-heavy utilities. But we need to watch the space. It's not over yet because of the reviews of most of these regulatory rule sets. We need to be aware that this is a space to watch looking forward.
Very good. Excellent. I think we're coming to an end of the questions. I enjoyed it very much again. Jan, it was a big pleasure to get your expertise here in the session.
Pleasure was all mine.
We follow on other occasions again. I say as well to the audience that I hope you enjoyed it as well. We are very happy to receive your feedback. So on the last two sessions, the 18 minutes and as well the talk with McKinsey, we were really, really grateful and encouraged by the feedback we got. Since the audience, the direct response is missing, Jan, and you see that as well, we always hope for some feedback afterwards. And hope to see you again. Next session is in about 2 weeks time again. We will announce it via emails or on LinkedIn. So I am sure you're not going to miss it. Thanks again and hope to see you soon. Bye-bye, everyone.
Thank you. Bye-bye.